Ladies and gentlemen, please now join me in welcoming the Honourable Chief Justice Geoffrey Ma. Chief Justice Ma was appointed the Chief Justice of the Court of Final Appeal on 1 September 2010. He was actually born here in Hong Kong and was in private practice in this city and, well, in Singapore after acquiring his legal qualifications, training and background in the United Kingdom. His profile may be found on page number 7 of the program, and I welcome Chief Justice Ma. Thank you.
Thank you for that. Dr. Berlusconi, Commissioners here, Secretary for Justice, distinguished guests, ladies and gentlemen, I too extend a warm welcome, in particular to those who have come from overseas. Much reference is made these days to themes of globalization and similar terms. The title of this conference uses the term increasingly connected world. It is of course appropriate to do so, but the significance of celebrating the 125th anniversary of the Hague Conference on Private International Law lies in the fact that these themes have been recognized right from the beginning of its history, and indeed represent the ideals and rationale for the continued existence of the HCCH. The founder of the Hague Conference, Tobias Asser, had this vision in 1893, and this was acknowledged in his receiving the Nobel Peace Prize, Nobel Prize for Peace in 1911. Asser was also instrumental in the formation of the Permanent Court of Arbitration from the First Hague Peace Conference in 1899, and he was also one of the founding members of the Institut de Droit International, the Institute of International Law. The TMS Asser Institute in The Hague is named after him. The premise of the HCCH is that a sound system of norms or rules of private international law, also known as the conflict of laws, fosters peace and stability among nations. Private international law features in almost every facet of human activity, and the HCCH has sought to achieve the harmonization of laws in relation to important aspects that have an international element, bearing in mind the underlying theme of comity. For our purposes, comity, an otherwise elusive word, especially for lawyers, can be defined as a recognition of the territorial relevance of other jurisdictions. As is reflected in the sessions of this conference, the HCCH has over the years, on the whole, but not exclusively, concentrated on family and children issues, international commerce and finance, and procedural matters. This is readily seen in the numerous conventions which have been the product of the work of the HCCH in fulfillment of Article 1 of the Statute of the Hague Conference, the progressive unification of the rules of private international law. I refer to some examples of this. In relation to family and children, the 1902 Guardianship Convention, the Hague Protection of Minors Convention, the 1980 Hague Abduction Convention. In relation to commerce and finance, the 1955 Convention on the International Sale of Goods, the 1958 Convention on the Transfer of Title in the International Sale of Goods, the 1958 Convention on the Selection of Forum in the International Sale of Goods, and in relation to procedure, the 1965 Hague Service Convention, the 1970 Hague Evidence Commission, the 2005 Hague Choice of Court Convention. There is an inherent acceptance in the work of the HCCH that the integrity and credibility of any legal system in a given jurisdiction is to a significant extent dependent on how that jurisdiction respects other jurisdictions, hence the importance of private international law. This is far from an academic exercise, as we can see from the importance of the way those topics of family and children law, international commerce and finance, and matters of procedure are dealt with. It is also dependent on the treatment of the aspect of fundamental rights. One is always anxious to know the extent to which any given jurisdiction pays regard to internationally accepted norms. In Hong Kong, the basic law, which sets out the constitutional position of Hong Kong as a special administrative region within the People's Republic of China, prescribes under Article 39 that the provisions of the International Covenant on Civil and Political Rights, the ICCPR, shall be implemented. The ICCPR thus finds legislative force in the Hong Kong Bill of Rights. In private international law, regard is had not just to fundamental rights domestically, but also to the extent that such rights exist and are in force in other jurisdictions when this is a relevant factor, such as in the context of the enforcement of judgments or in relation to questions of jurisdiction. In the course of my own legal career, both as a barrister and as a judge, I have seen that the approach of the courts reflects the spirit that the HCCH sets out to foster, namely, that the goals of justice and basically doing what is right can only be examined in a worldwide context and take into account the perspective of other jurisdictions. In an increasingly unpredictable and even volatile world, the work of the HCCH remains critical. I congratulate the HCCH on its 125th anniversary, but more than that, I congratulate the continuing work of the HCCH in meeting the many challenges it faces and to take the right opportunities in this complex world in order to meet them. Thank you.